For me, this document, I would say, is the master template of what is wrong with all the HRC legislations, the Hindu religious and charitable endowments legislations across the country. I'll tell you the background of this document and then we'll. So there is an infamous section in the Tamil Nadu Act, which is section 45, which deals with appointment of executive officers by the state to Hindu institutions, who will be in charge of the administration of that particular place. In 1965, the Supreme Court came out with a decision, again in relation to a Tamil Nadu institution. And that state has a peculiar history when it comes to how it manages temples, how it treats temples. Specifically saying that under no circumstances will the state encroach upon the administration entirely. Why is this? Because Article 25(2)(a), from which the state draws its power, specifically refers to only regulation or restriction of secular activities, not entire control, not administration. Iska matlab ye hai that you will give a framework for a specific objective, for a specific purpose, to curb a certain mischief or a mismanagement, and you will let the community choose its own appointees who can implement that framework, but you will not impose yourself into that framework, nor will you let your state appointee entrench himself inside that framework, because that would result in complete takeover of the administration. The Supreme Court in the judgment categorically strikes a distinction between supervision and takeover of administration. In 2015, correct, 2015, the Supreme Court comes out with another decision, 6th of December 2014, 6th of December. 2014, the Supreme Court comes out with another decision where Mr. Subramania Swamy was actually representing the cause of the Sabhanagar temple, famously known as the Chidambaram temple, where the Supreme Court categorically interprets Section 45 and the general scheme of these legislations to say the state, if it has to respect the rights of religious denominations under Article 26 to manage their own institutions in accordance with law, should not impose itself entirely into that institution. And it says you are limited to regulation and restriction but not takeover of administration. It has categorically said so. What was this judgment passed in the context of? From 1954 to 2014, until the day of the judgment, executive officers were appointed across the state in the state of Tamil Nadu with respect to every temple, including temple which has, let's say, revenue less than 1 lakh or 10,000, so on and so forth. They've appointed. They've all been taken over. But no reasons or no speaking order has been passed as to why the temple deserved to suffer the presence of an executive officer in the first place. If you appoint an executive officer with respect to a certain temple, आपके मन में इतना तो होना चाहिए कि दाल में कुछ काला है, and that must reflect on paper. And you must give reasons. This is the basic principle of natural justice. When a state chooses to interfere with the administration of a private institution, tell us the reason why you think it is your right to walk into this place. Not a single reason was offered. No evidence was placed before the Supreme Court as to why so many executive officers were appointed across the state of Tamil Nadu. And importantly, when an executive officer is appointed, he can stay in that place only as long as the mischief exists. Once the mischief is rectified or corrected, he has no business sitting in that place. He has to get out. He has no other option. He has to be necked out of the place. All these orders are indefinite insofar as the time is concerned. That means, ek baar baith gaye, to baith gaye. There is no way he'll get out of the place. So the Supreme Court says, all your appointments under Section 45, if they are in violation of two conditions, meaning you have not identified the mischief, nor have you set a time period, they are all violative of the Constitution and Article 26. That's what the Supreme Court says.